Good afternoon, everyone. Thank you for joining me today, and a special thank you to the Miami Beach Chamber of Commerce for affording me this platform to talk to its membership about a very important topic, especially now that we're coming up on April 1st and a lot of commercial lease payments are due, and landlords and tenants don't understand how this global pandemic is going to impact their contractual obligations. And that doesn't just stop at leases. I mean, this is really any contract that you have with a vendor, creditor, debtor, any situation like that. I think the first point that is of crucial importance to mention is that we're in this together. No one person is in a different situation or a better situation. And so we should be conducting our business with a sense of compassion and empathy. Unfortunately, that's not going to be the case across the board. And with all the assistance we're getting from the federal, state, and local governments to try to keep our businesses and protect the economy through these different disaster relief programs, it still doesn't answer the questions as to contractual obligations. Now, in order to understand the contractual obligations, I think the first question is, are they enforceable during a global pandemic? And the short answer to that is yes, they are. But you want to go to your contract to understand what other relief might be within that contract, or whether your contract even speaks to this issue, so you can go outside of the contract to seek relief. The first part of the analysis is the contract itself, like I said. And for sake of this webinar, we're only going to talk about and consider written contracts, but I think it's important to bear in mind that there are also oral contracts that may be enforceable if they're not required to be in writing by law. So although we won't touch on that, a lot of the concepts are going to be the same, all right? So the contract. A good contract is one where the parties have memorialized their agreement and dictated how every situation is going to be resolved as they arise. Now, the foreseeability of an issue is going to be crucial to this analysis for purposes of this webinar. And you need to know if this issue was mentioned within your contract, because that will dictate whether it was foreseeable or not. Now, there's also considerations come outside of that, but that's the first layer, right? We want to know, does your contract specifically state, in the event of a governmental order that interrupts business, in the event of a global pandemic, which sounds bizarre, but we have to remember that SARS only happened a couple years ago. And because of SARS, a lot of insurance companies, landlords for commercial spaces have started to speak to viral pandemics. So it's very possible that maybe it's not using that specific language, but talks about governmental orders that would address that issue. So let's assume, which is I think still going to be the majority of contracts right now, that issue is not addressed. So what's the next step? And I think the most commonly known phrase in this type of situation is force majeure. But as we're learning through this process, there's an educational gap as to understanding what that means, how it's applied, and what relief does that grant a party to a contract. The first step in the written contract, you would go down to that section and you would read it, because, and for those of you that don't know, force majeure is basically any act of God or any occurrence that is out of a party's control should excuse them for their obligations under a contract, right? But every force majeure clause is not written the same. And that's increasingly becoming the case. And one that I'm seeing with some frequency is when commercial landlords are including an exception to rent payments. So the force majeure clause would say, in the occurrence of an act of God, all parties are relieved from their obligations under their contract, with the exception of rental payments. In other words, too bad, so sad, just pay me my rent. Doesn't matter what's going on. Does the analysis stop there? No, it doesn't. You also want to look through the contract to see if the contract speaks to what a default is, what happens in the event of a default, how to cure a default, right? Because that's going to be other timelines and resources that are available to you to gauge how to handle this situation. Because I think we can all agree that we're not sure when it's going to end, but it will end. And it may enough time for you to cure a default. So that would be a good opportunity to dive into those federal, state, and local programs to see if they can assist you in curing a default. Then the next step would be to check to see if there's any talks about a rent abatement. A rental abatement can be a number of things. It could be pushing the rent payment to the end of the loan, increasing the rental payment slightly to accommodate for a month or two of non-payment. And I doubt that they would get into specifics in a contract, but it's something that you can utilize to then reopen negotiations for amending the rental payment term or any payment term or any contract term for this short period of time. So then after that, most contracts, large contracts at least, would require some type of insurance. You would want to look into your contract, into the provisions that speak about insurance, to see whose obligation is it to hold the policy, what policies are they required to hold, and what we're really looking for is business interruption insurance. Now again, it doesn't stop for purposes of business interruption insurance at the analysis of your contract, but also your insurance policy. You're going to want to go to your insurance policy or contact your insurance broker to find out if this situation that we're currently in is covered under that section of your policy. There's certain case law out of Florida where insurance companies have been successful in arguing their way out of business interruption coverage for certain situations, and this may be one of them. I think there's a litany of litigation that comes out of this situation that we're all going to learn from. Aside from that, you're also going to want to understand what the contract that you can rely upon. And there's the force majeure, which is similar to the doctrine of impossibility. We already spoke about force majeure. Impossibility, that one is a little bit difficult to argue in the current situation because, like I said, this is more than likely going to be a temporary situation, and impossibility, depending on the nature of your contract and the obligations of your contract, it may not be impossible to act forever, right? So if this is a contract for 5 years, then this is really a temporary, and that may not be enough of an issue for you to rely on that doctrine. The doctrine, in essence, says that when a contract is impossible to perform, it is no longer enforceable. So it's really understanding what your contract requires, and is it truly impossible at any point. Also, you have to take into consideration we're in a virtual age. It can be conducted with third-party vendors. There's a litany of ways that it's possible for you to conduct or come through with your obligation that would take you out of the protection of the doctrine of impossibility. Next, we have the doctrine of frustration. This one, again, depending on the nature of your contract, may be more likely avenue for relief under a contractual obligation. And the doctrine considers the underlying purpose of the contract being frustrated. So an example of that would be if you rented an auditorium, right? And this auditorium, you were going to host an event where you were inviting all these people. That obviously cannot happen because of the orders that are currently in place. That has completely frustrated the purpose of your contract. This would be a good opportunity to go to your landlord and advise them of the situation. I'm sorry, not your landlord, but the other party, and advise them of the situation and see if you could come to an alternate agreement in lieu of terminating the contract. But this doctrine in that particular situation may afford you the opportunity to terminate it in its entirety. And if you put down a down payment, may even allow you to get that down payment back. There's also, for creative persons and parties to a contract, you know, this is probably more if you have a brick and mortar or, you know, a physical location that has been forced to be closed, is, you know, an eminent domain or a condemnation argument. Particularly, there's a theory called inverse condemnation, where it's not a full taking of the property, but agency with the power to execute eminent domain has basically prevented you from the use of that property. This is going to be an argument that most landowners are going to turn back to the government and say, look, you know, you guys forced us to close. We understand the situation, but we need some relief. So this is, you know, something that you want to utilize to ask what actions are being taken to mitigate damages, so that, you know, the other party can understand what type of set off they can expect. And this is a good place to start negotiations, where each party understands, okay, well, I can get this from this program, so that's going to reduce my exposure, and so this is what I can offer you. And then that way, not one person is carrying the burden during these very difficult times. And again, I think that, but the essence of the webinar, and the reason I wanted to speak to everybody, was so that everybody understood their obligation, and knew what to look for in their contracts. Again, I want to reiterate that this shouldn't be taken an opportunity to walk away from your contracts, but more so to find a way to work with the parties you've already have a contract, and make sure that we're all doing our part to keep the economy strong, and so that we can bounce back from this quickly. I wanted to provide you my email address. It's Arturo, Arturo, @tremblylaw.com. We also have several resources on our firm website, tremblylaw.com/coronavirus, where we're keeping, you know, the public informed as new programs roll out, new laws get put into place, and anything else that we're finding to be a common issue across the board for business owners, and address those as quickly as possible. Thank you again for being here today, and I appreciate your time. Take care.